Supreme Court of India A.K. Sarkar and Company and another versus State of West Bengal and others decided on March 7, 2024 SEC Online SC 248 facts of the case. On December 6, 2000, a food inspector while inspecting the shop/godown of the appellants took samples of some sugar-boiled confectionaries. After payment, purchased 3 packets of 500 grams each. The packets did not show the prescribed particulars such as complete address of the manufacturer and the date of manufacturing, thus, violation of Rule 32, C, and F, of the Prevention of Food Adulteration Rules, 1955. The inspector filed a complaint before the trial court under Section 16, 1a, I, read with Section 7 of the Act. The appellant was convicted. Appellant number 2 and Amit Kumar Sarkar were sentenced to undergo simple imprisonment for a period of 6 months along with a fine of Rs 1,000 each, whereas appellant number 1 was directed to pay a fine of Rs 2,000. Findings of the court. There are concurrent findings of 3 courts below, and there is absolutely no question of us having any measure of doubt as to the findings, inasmuch as that the packets which were taken from shop/godown of the appellants were misbranded as defined under Section 2(9)(k) of the Act, as they were not labeled in accordance with the requirements of the Act or the rules made thereunder. The only question which now remains is of sentence. The prohibition contained in Article 20 of the Constitution of India is on subjecting a person to a higher punishment than which was applicable for that crime at the time of the commission of the crime. There is no prohibition for this court to impose a lesser punishment which is now applicable for the same crime. The Prevention of Food Adulteration Act, 1954 was repealed by the introduction of the Food Safety and Standards Act, 2006, where Section 52 provides a maximum penalty of Rs 3 lakhs for misbranded food. There is no provision for imprisonment. This court in T. Barai v. Henry Aho, 1983, 1 SCC 177, had held that when an amendment is beneficial to the accused it can be applied even to cases pending in courts where such a provision did not exist at the time of the commission of offence. The above principle was applied by this court again in Trilok Chand v. State of Himachal Pradesh, 2020, 10 SCC 763, and the sentence of 3 months of imprisonment and Rs 500 of fine for misbranding. Under the Act, 1954 was modified to that of only a fine of Rs 5,000. The present appellant number 2, at this stage, is about 60 years of age and the crime itself is of the year 2000, and 24 years have elapsed since the commission of the crime. Considering all aspects, more particularly the nature of offense, though we uphold the findings of the courts below regarding the offense, but we hereby convert the sentence of appellant number 2 from 3 months of simple imprisonment along with fine of Rs 1,000 to a fine of Rs 50,000 only. The sentence of appellant number 1, which is for a fine of Rs 2,000, is upheld. The appeal is partly allowed.